This is lecture number 2, Forms of Business in California. What different types of business entities are available to contractors in California? Business types in California. For California contractors, there are 4 main business entity types to choose from. There can be a 5th one if they already have a contractor's license, but in general, there are 4 main business entity types to choose from. Although most contractors, they only pick 1 or 2 of them. There are 2 that are predominant and heavily picked, and there are a couple that are very rarely picked. The first one that is the most common for most new contractors is the sole proprietorship, also known as sole owner, and sometimes I will refer to that as SP. Then there is the partnership. If 2 or more general partners, a partnership requires that business entity type requires at least 2 people to form it, and that's sometimes referred to as part. Then the third one is corporation. A corporation, you're going to be able to tell if something is a corporation because it's going to have Inc., INC, or Corp. That will usually be after the business name. They'll either have Inc. or Corp, and that's usually a really good indication that that business entity is a corporation. Then there is the limited liability company, and that's frequently referred to as an LLC. Then there is a joint venture. A joint venture is made up of 2 or more licensed contractors in California. So where do you find out more information about business entity types for contractors in the state of California? You can look it up at Business and Professions Code section 7065 and the statutes that follow that. So what factors do contractors consider when they start up a new business? When they choose their business entity type, what kind of factors do they consider to determine which business entity type that they want to choose? There's 6 main factors to choose from that to consider when choosing their business entity type. First is level of management. How involved do they want to be in managing their business type? Do they want limited or unlimited liability? That's the second factor, limited or unlimited liability. Number 3, bond requirements. There's for some types of businesses, they have different bond requirements. For the vast majority of them, they're all the same, but there can be some additional requirements. 4, insurance requirements for workers' comp and commercial general liability insurance. 5th, profits and losses. That's another factor to consider. And the 6th one, frequently combined with the 5th one, is taxation. Sole proprietorship. The sole proprietorship is the simplest form to start and manage. If a contractor uses his or her own name as the name of the business, then the only requirement is obtaining a contractor's license to start. As soon as they get the contractor's license, if they're using their own personal name as the name of their business, they're good to go. They can start doing business right away. If the contractor doesn't want to use his own personal name, instead he wants to use a fictitious name, a false name, a name that the contractor he or she made up, then they must get a contractor's license and, in addition to that, obtain a DBA, doing business as, at the county recorder's office. You obtain a DBA, doing business as, at the county recorder's office. And if you're using a fictitious name, that has to be recorded before you can do any business. Your name has to be, your false name, your fictitious name, has to be recorded with the county recorder's office before you can conduct any business. A sole owner has unlimited liability, meaning that the contractor remains liable for the entirety of a judgment against him or her, against their business. Any judgment against their business, they remain liable for. Any debts that they owe, that the business owes, the contractor remains liable for. The only bond requirement for a licensed contractor is a $25,000 contractor's surety bond obtained from a surety insurance provider, typically costing about $100 to $200 a year. For a long time, up until 2023, that was the bond requirement was $15,000 for the contractor's surety bond. But it just went up in January of 2023, and it is now $25,000. $25,000 contractor's surety bond. It costs somewhere between $100 to $200 per year in order to have that bond. Sole proprietorship bonds. If a harmed party files a claim against the contractor's bond, what can they get? Can anybody get $25,000? Can anybody who files a claim against the contractor's surety bond get up to $25,000? No, it's not just anybody who can get $25,000. It's only for homeowners. It's only homeowners that can get up to $25,000. And it's only homeowners involved in a home improvement contract. Only residential homeowners who file a claim against the contractor's surety bond in regards to a home improvement contract can they obtain up to $25,000 from the surety bond. Everyone else can only obtain up to $7,500 from the bond. That can be a bit shocking for people if they have a house built from scratch. They have a brand new house built and they're unhappy with the contractor. They file a claim against his surety bond, and the surety bond company says, okay, well, yeah, you've got this claim, but you can only get $7,500. And usually the homeowners are a bit shocked by that. They're like, wait a minute, the contractor's surety bond is for $25,000. They're like, no, sorry. By statute, the most you can get is $7,500. Where do they come up with that rule? Business and Professions Code sections 7071.5 and 7071.6 talk about the contractor surety bonds and who can collect what when they make a claim against that bond and for what they file the claim for. No other bond required unless the contractor has been disciplined by the CSLB or has a judgment against him or her. Sole proprietorships and workers' comp. Does a sole proprietorship have to maintain a workers' comp policy? A sole owner is not required to have a workers' compensation policy unless the sole proprietor has employees, in which case it is required. If they have employees, they have to have workers' comp. If they don't have employees, then they do not have to have workers' comp. Frequently, people will ask, what if they have a family member? Or what if they hire a day laborer? Do they have to have workers' comp? Yes. If they have somebody working at their job site, they do have to have a workers' comp policy. Even if it's a family member, even if it's a day laborer, somebody they picked up at Home Depot, they still have to have a workers' comp policy if they have anybody working for them at a job site. However, the exception is if the contractor has a classification of license in which a workers' compensation policy is required. For some classifications, even if the contractor has no employees, they still have to have a workers' comp policy. Why? I don't know. That's just the rule. I guess the CSLB thinks that these people are going to have workers. And if they say they don't have workers, maybe they're being dishonest. Um, for some, it really makes sense that they would have workers, and it would be, I would think, for most contractors, it would be incredibly difficult to work on a project without any employees. Some of those classifications in which they are required to have workers' comp, regardless if they have employees, C39 roofing. That has been a requirement for a long time. Roofers, they have to have a workers' comp policy. C8 concrete, that's new as of 2023, the year 2023. C8 concrete contractors have to have a workers' comp policy. C20 HVAC, they have to have a workers' comp policy. That one doesn't really make a lot of sense to me, but I don't know. Made sense to the CSLB. C22 asbestos and D49 tree trimming. D49 tree trimming, they have to have a workers' comp policy. I don't know about that one either. I've seen a lot of tree trimmers work on their own without employees, but I don't know. CSLB says they have to have it. All right. Working with employees without workers' comp exposes the contractor to civil and criminal liability, plus disciplinary action by the CSLB. Business and Professions Code 7125 through 7127 discuss disciplinary action by the CSLB. If a contractor has employees and they don't have a workers' comp policy, and the CSLB finds out, most likely that contractor's license is going to be suspended until they provide the CSLB with a certificate from their workers' comp carrier. Certificate basically says that they have a workers' comp policy. Criminal liability. It is a misdemeanor crime for an employer to have employees but not have workers' comp. Labor Code 3700.5 discusses that it is a misdemeanor crime for an employer to have employees but not have a workers' comp policy. Civil liability. So if a contractor has employees, but they don't have a workers' comp policy, and the CSLB doesn't find out, the district attorney's office, law enforcement, they don't find out. But then, for some reason, the contractor gets sued. Or a better example would be the contractor sues a homeowner. They sue a homeowner for breach of contract. Homeowner hasn't paid the contractor what the contractor's owed. And then through the discovery process, the homeowner finds out, or more likely the homeowner's attorney finds out, that the contractor did not have a workers' comp policy. And through discovery, it's determined that what was known by the homeowner who saw all these workers on a job site, that the contractor obviously had workers. They weren't subcontractors. They weren't licensed subcontractors. They were workers. But there was no workers' comp policy. It's not uncommon for the homeowner's attorney to request information from the CSLB as to the contractor's history. They get a certificate of records of the contractor's history, and it will show if they have workers' comp or not. Once the property owner finds out that the contractor did not have workers' comp insurance, the contractor's case might just get tossed out. If the contractor filed the lawsuit for breach of contract due to non-payment, but the contractor did not have a workers' comp policy, by operation of law, that contractor is unlicensed. His failure to have, or her failure to have, a workers' comp policy, but having employees, by operation of law, they are an unlicensed contractor. And an unlicensed contractor cannot file a lawsuit in the state of California. So there's a good chance that case would get tossed out due to the failure to have a workers' comp policy. sole proprietorship and commercial general liability insurance. A sole owner is not required to have commercial general liability insurance. However, not having it exposes the contractor to unlimited liability for what may be greatly reduced if the contractor did have an insurance policy. Commercial general liability insurance covers accidents. It doesn't cover intentional acts by the contractor, but it does cover accidents. Accidents that harm the property and non-employees on a construction site. Now, the employees, they're going to be covered by workers' comp if they get injured, but non-employees, they should be covered by commercial general liability insurance if they get injured on a job site. For example, if a pipe is accidentally broken and the house is flooded, that should be covered by commercial general liability insurance. That's an accident. A pipe gets broken during construction, it floods the entire house, and they shut off the water main, but still in the meantime, the house gets flooded, and a whole bunch of the flooring and the subfloor and the sheetrock and the lumber and the walls, it all gets soaked and damaged and has to get replaced. That's an accident. That should be covered by commercial general liability insurance. Another example, if a solar panel system is put on a roof and that was installed in a manner in which it causes leaks that damage the structure below, that should be covered by commercial general liability insurance. However, should note, commercial general liability insurance covers accidents. So if something is going on for a long period of time and everybody knows about it, but they don't make a claim right away once they discover something's wrong. If they just kind of sleep on it and they just let the problem get worse and worse and worse, that might not be covered by commercial general liability insurance because it covers accidents. It doesn't cover harms that go over a long period of time due to the negligence of the property owner and not getting it repaired, like the homeowner contributing to the harm, contributing to the negligence. That might be grounds for the commercial general liability insurance company to be like, hey, you had a duty to let us know what was going on. You didn't do so, so we're not going to cover you. Whether they should be covered or not, it's debatable. But in general, if there's an accident, if there's a sudden event that causes harm to the property, that is generally going to be covered by commercial general liability insurance. CGLI has a claims handling process, and the insurance carrier has a duty to defend the contractor for any claim involving an accident covered by the commercial general liability insurance policy. Contractors don't have to have commercial general liability insurance, but it's pretty much insane not to have it. If a contractor has insurance and if they get sued, the insurance company has a duty to defend the contractor. If they're being sued for anything related to arguably what should be covered by insurance, then the insurance company has a duty to defend the contractor. That in itself can save the contractor tens of thousands of dollars in attorney's fees, because it's the insurance company who pays the attorneys. It's not the contractor. And the insurance companies, they try and settle the claim for what is covered under the policy. And so that can save the contractor hundreds of thousands of dollars that he would otherwise have to pay if it wasn't for having insurance. So does a sole proprietor have to have insurance? No, they don't. But nowadays, it's pretty much insane not to, because it doesn't cost that much and it could save a contractor from financial ruin if they have an insurance policy. Sole proprietorships regarding profits and losses and taxes. The business's profits are the contractor's profits. The business's losses are the contractor's losses, for which the contractor is solely responsible for. If it's a sole proprietorship, It's the contractor who's solely responsible for any losses and paying off any debts related to the business. A sole proprietorship does not need to maintain records for profit and loss, with the exception of for reporting taxes. This is performed by providing the contractor's accountant with an income statement at the end of each year. That will be covered in a subsequent lecture. From the income statement, the accountant is able to determine the contractor's taxes. In addition, you've got your Social Security and Medicare for the contractor, and that's derived, that number, the amount that's owed to the IRS is derived from the contractor's business profits. I should note that a contractor does need to maintain their business records for up to 5 years. They do need to maintain the records for 5 years, all their business records for 5 years. After 5 years, you can destroy your business records, but you do have to maintain them for up to 5 years. Partnerships. A partnership is formed by a partnership agreement between 2 or more people. It's got to have at least 2 people to share in the profit and losses of a business. Generally, filing of the partnership agreement with the state is not required, but in California, the partnership license must be filed with the Contractor State License Board, and a DBA, doing business as, must be filed with the local county recorder's office. So for California, if it's a contractor's company and they want to have a partnership, they want to have 2 or more owners, they do need to file that partnership with the CSLB. Their license will be designated as a partnership. Don't see too many of those, but if you're going to do a partnership, you do have to be recorded with the CSLB and the county recorder's office. The management of a partnership is as simple as a sole proprietorship. They don't have to do a lot of bookkeeping. They don't have to do a lot of record keeping. It's kind of insane not to, but they don't have to. The partners are agents of the business and are liable for all the actions of all the partners. So with a sole proprietorship, the sole proprietor is only responsible for their own actions. They and their business are one and the same. So they're responsible for whatever they do, whatever their business does. But with a partnership, the partners are not only responsible for the partnership, they're responsible for each other and anything that's related to the partnership. If any partner does some business for arguably, not maybe necessarily, but at least arguably for the benefit of the partnership, all the partners are liable. So if one of the partners, they buy some really expensive equipment that the partnership doesn't really need, and it needs to get paid off, all the partners are liable for that debt. All the partners are responsible for that debt. Bonds, partnerships and bonds. A partnership must have the basic contractor's surety bond in the amount of $25,000. That's probably the only bond they need, but they might need an additional bond. If the qualifying partner of a partnership has less than 10% ownership in the partnership, then the qualifying partner must also obtain a qualifier's bond. Qualifier's bond in the amount of $25,000. So they might need 2 bonds, but they only need the second bond if the qualifying partner has less than 10% ownership. So what's a qualifier? What makes one of the partners the qualifying partner? The qualifier for license, for a contractor's license, and every license requires them, not just partnerships, sole proprietorship, corporation, LLC, every single license needs to have a qualifier. The qualifier is the person that has met the experience requirements. They've got at least 4 years of journey person level experience in the trades, whatever trade that they're going for, that they're getting the license for. And they met the examination requirements for the license. They took the CSLB, the Contractor State License Board exam, and they passed it for both the law portion of the exam and the trade portion of the exam. Every license has to have at least one qualifier. They can have multiple qualifiers. Like you could have a partnership with like 5 partners, and if they all took the CSLB exam, they all passed the CSLB exam, and they all have at least 4 years of journeyman person level experience, well, then you have a whole bunch of qualifiers. You have 5 qualifiers, but you only need to have one. Each license only needs to have one qualifier. Insurance. The partnership is required to maintain a workers' compensation policy that covers all working partners. Sole proprietorship doesn't need to have that, but a partnership does. The working partners need to be covered by workers' comp. The partnership is not required to maintain a commercial general liability insurance policy. They don't have to have insurance. It's pretty much insane not to, but they don't have to have insurance. Partnership, when it comes to profit and losses and taxes, partners share in profit and losses as designated by the percentage of ownership as stated in the partnership agreement. So you might think, okay, so there's 2 partners, profits and losses 50-50. That could be the case, and if nothing else is left stated, that probably is the case. But it could state differently in the partnership agreement. It could be that somebody contributed more. It could be that somebody is designated to work more. And then however they have that in their partnership agreement, that might be the breakdown for their profit and losses. The partners are taxed based upon their percentage of profit. It's pass-through taxation, just like a sole proprietorship, whatever the business's profits are, that's what the partners are taxed on, just like with a sole proprietorship. But it could be their percentages might be different, so that's how they break down what their taxes may be. All right, corporation. Sole proprietorship is very common for new contractors. A partnership is not common at all. But a corporation is also very common in a lot of sole proprietors that they start off as a sole proprietorship. They might convert to a corporation over time. All right, a corporation is formed by filing articles of incorporation with the California Secretary of State and subsequently the license with the CSLB. Every officer of the corporation, as stated with the Secretary of State, also needs to be listed with the CSLB. A corporation requires more management than a sole proprietorship and a partnership. The corporation requires corporation documents, including in part the articles of incorporation. That's the original document that starts the commencement of the corporation. Statement of information needs to be periodically filed with the California Secretary of State. It says any new things that happen to the corporation, who the officers are, maybe new officers, their new business address if there is one, their agent for service of process if they get sued, who receives the lawsuit on behalf of the corporation. It could be one of the corporation officers that is the agent for service of process, or it could be somebody else. Then there is the corporate bylaws, the basic information about what is this corporation about, who's supposed to get what are the percentage breakdowns, and then minutes of hearing. For every meeting that the corporation has, frequently at least once a year, they should have a minutes of hearing. They should have a meeting, and they should have the minutes for those hearings, for those meetings. The contractor must pay an additional tax fee every year for the benefit of the corporation. Up until recently, up until 2022, it was about $800 per year. It might have gone up, but it was $800 per year that the corporation had to pay in order for the benefit of having the corporation. They did have to pay that fee at least once a year. All right. Corporation liability. This is one of the main benefits of having a corporation is that they have limited liability. A corporation is its own legal entity. Therefore, the corporation itself only remains liable for claims against the corporation. The officers of the corporation are not liable for the acts and accidents of the corporation, and therefore are protected by, in essence, what is called a corporation shield. The corporation officers are shielded by the corporation. They are protected by the corporation. Their personal assets are protected by this, what is referred to as the corporate shield. Officers are not liable for the acts of the corporation unless they could be found liable. Generally not, unless the corporate officers intermingle corporate funds with personal funds. For example, they decide they want to get a new car for their spouse. They use the corporate funds to buy that new car for their spouse. Well, that's commingling corporate funds with personal funds. That's a no-no. The corporation is undercapitalized. There's not enough money to pay all the debts owed by the corporation. It's just a sham corporation to hide money or to protect personal asset money. If a corporation is undercapitalized, that might expose the officers to personal liability. Or the officers commit intentional torts. If they commit an intentional tort, they harm somebody, they intentionally harm somebody. Well, that might lower the corporate shield and make those officers personally liable for what they did. Intentional torts in construction contracts typically are a result of fraud and intentional misrepresentations by officers in order to get advance funds from a homeowner. Here's an example of that. So in California, for a home improvement contract, the contractor can only get paid for work performed and materials delivered. That's it for home improvement contracts, not for other contracts, but for home improvement contracts. The contractor can only get paid for work performed and materials delivered. That's under Business and Professions Code 7159. Now, if an officer of the corporation, they say, hey, you know what, homeowner, we're going to need the material money up front. We're going to need $15,000 for materials up front. Before we even order the materials, we need that money up front. They can't do that. That is arguably fraud. They know they're not supposed to do it. If they know the licensing laws, which they took an exam to understand those licensing laws, but if they demand money up front that they're not entitled to according to the Business and Professions Code, well, that's arguably fraud and arguably an intentional misrepresentation. And that probably is going to lower that corporate shield and expose that officer to personal liability. Corporation bonds. A corporation must have the basic $25,000 contractor's surety bond. They got to have at least that, just like with a sole proprietorship, just like a partnership. If the responsible managing officer, the RMO, that's the qualifier for the license, has less than 10% ownership, then a qualifier's bond is also necessary. Actually, I'm sorry, on that slide it should say $25,000. Used to be $12,500, but now it went up to $25,000. They do have to have the qualifier's bond as well. Corporations insurance. A corporation does not need to maintain a workers' compensation policy for its officers unless it's required by its classification. C8 for concrete, C20 for HVAC, C22 asbestos, C39 roofing, D49 tree trimming. They have to have workers' comp. But if they're not one of those classifications, they do not need to have workers' comp for the officers. Excuse me. If they do get a workers' comp policy for their employees, but they do not want to have officers to be covered by that workers' comp policy, then they need to sign a waiver. They need to file a waiver where the workers' comp provider letting them know that the officers are not covered by the workers' comp policy. Because what will happen if they don't submit that waiver? And the insurance company isn't going to say anything about it. At the end of the year, there's going to be the audit by the workers' comp provider, and the workers' comp provider will demand a whole heck of a lot of money for the coverage of all those officers. And those officers will say, "Hey, wait a minute, we're not supposed to be covered by the workers' comp policy." And the workers' comp carrier will say, "Well, did you sign the waiver?" And they usually didn't. The officers usually didn't, and then they owe like tens of thousands of dollars because of that additional coverage that they didn't even know they had, but they did, and the carrier never told them about it. All right, a corporation does not need to maintain a commercial general liability insurance policy, but not having one may expose the officers to personal liability. It's insane not to have commercial general liability insurance if you do construction. It is so freaking easy to have an accident in construction. It is so easy to break something. And that insurance could save a contractor from financial ruin if they have it. If a corporation doesn't have it, that doesn't look too good for the corporation. And it could expose, not necessarily, but it possibly could expose the officers to personal liability if the corporation, which they know should have an insurance policy, but it doesn't. It's an argument. It's debatable. All right, corporation, profit and losses and taxes. The corporation is entitled to profits and required to pay the losses. If a C corporation, the corporation is taxed, and also the shareholders are taxed based upon dividends received. It's got double taxation for a C corporations. Dividends, in essence, being the profits of the corporation paid out to the shareholders. Now, frequently they're the officers and other people as well. Anybody who has a share of the corporation, they usually want to make profit on whatever, they put money into this business. They're expecting to get money in return. So it's the corporation is in itself taxed in the C corporation, and also the shareholders are taxed for any profits they receive from the dividend payments that could be quarterly or yearly, usually quarterly. If in an S corporation, the officers can be paid a salary rather than based upon the profit of the corporation. Therefore, their personal taxes for Social Security and Medicare, 15.3%, to the IRS can be, sorry, I blocked out a portion of what I wrote there, but the Social Security and Medicare payments, that can be based on their salary rather than being based on profits. So in an S Corp, you got the officers. The officers should be receiving a salary. And then Social Security and Medicare is going to be based on the salary instead of based on the corporation profits. So it could greatly reduce the amount of money that is owed to the IRS because it's based on salary rather than profits. Okay, limited liability company. Limited liability company. An LLC must be registered with both the California Secretary of State and the Contractor State License Board. When it comes to an LLC, a lot of attorneys that don't do construction law, they will tell contractors, hey, you should do an LLC. Don't do a sole proprietorship. Don't do a corporation. Do an LLC. And for most people, that makes a lot of sense. But the CSLB doesn't really want contractors to have an LLC. So they put additional requirements for contractors to have an LLC that make it so financially burdensome that most contractors do not form an LLC. An LLC is easier to manage than a corporation. Articles of organization must be filed with the Secretary of State, and the managers must be listed with the CSLB, but they don't have as many records to keep as a corporation does. An LLC has the same limited liability protection of a corporation, and the managers are generally not liable for claims against the LLC. There's a lot of benefits, less paperwork, still you got the same amount of protection. However, there's a downside to it. An LLC is required to have a $100,000 contractor surety bond instead of the $25,000 bond. That's Business and Professions Code 7071.6.5. Instead of a $25,000 bond, they have to have a $100,000 bond. I don't know why they don't require the same thing for corporations, but they only require them for LLCs, and that's going to cost a lot more than $200 a year to have that $100,000 bond. In addition to the $100,000 bond, an LLC is also required to have a commercial general liability insurance policy at all times. The LLC's contractor's license will be suspended if the LLC lapses in reporting their bond and insurance policy with the CSLB. Corporation doesn't have to have an insurance policy, but the LLC does have to have an insurance policy, and it has to be active at all times. The LLC has pass-through taxation for its managers, as do the sole proprietorships and the partnerships. There is no double taxation and no manager salary requirements, so that's one of the benefits of having an LLC. The FICA, Social Security, and Medicare are based upon each manager's share of the LLC's profits. They can get salary as well. They can do a salary, but they can also be, taxes can be based on their profits and losses. Joint venture. A joint venture is when two or more contractors form a business and both wish to have the benefits of being the prime contractor on a project or multiple projects. Usually it's contractors that they get together for a limited time to work on some really big type of project, and that's the only thing that they're going to do. But they could do more, and that's called the joint venture. Summary. A sole proprietorship is the easiest type of business to form and manage. If it has a fictitious name, then a DBA must be filed with the county recorder's office. A partnership is the most dangerous type of business entity. As like an SP, there is unlimited liability, but unlike an SP, the partners are responsible for each other's acts. You're not only responsible for yourself, you're responsible for whatever your partner does as it relates to the business. If they do something on the side, if they go kill somebody not related to the business, of course the partner is not liable for that. But if they do something that harms somebody in the course of business, then yeah, all partners are going to be responsible for whatever that bad partner did. An LLC is easy to form and manage, has limited liability, which is great, protects its managers, it's easy, straight through taxation, but it's expensive. But it's expensive in California for contractors due to that $100,000 bond requirement and the necessity to have commercial general liability insurance at all times. That requirement that they have it insurance at all times. A corporation takes more effort to form and manage, but has limited liability protecting its officers, which is great. Taxes are more complicated with either a C Corp double taxation, but then you can have S Corp taxes, profits in any and officer salaries. You can have the S Corp taxes tax the profit, and you can tax officers' salaries. And the officers' tax burden might be limited, might be reduced if they're taxed based on salary rather than profit. Okay, any questions? Questions, you can contact me. My office phone number is area code 831-288-0297, or you can go to my website at brianlaw.com. All right, thank you very much.